in the event of fact, the legal consequence will be different. In other words, if the alleged fact is the crime, the consequence was the penalty. If the supposed right is the dangerous state, the legal consequence is the security measure. And if the supposed fact is the asset imbalance, is civil liability being understood by criminal law as a set of norms, a primary norm or a secondary norm that's mixed? This is what determines the essence of the norm. The primary rule is the one addressed to the citizen, prohibiting him if it is a crime of action or ordering him to avoid a result if it is a crime of omission. And the secondary rule is the one addressed to the judge that requires him to apply some of these legal consequences. Let us now turn to another subject: incomplete criminal laws and blank criminal laws. What is the general rule? It might be thought that most of the articles of the criminal code relating to the general part, as well as those defining crimes and misdemeanors in special laws, constitute complete norms because they respond to the structure, assuming de facto legal consequence. However, the doctrine has noticed the incomplete and complementary nature of the precepts provided for in the general part that are usually forgotten, and that the precepts integrated in the special part are also incomplete, since neither of the two precepts contains by itself complete criminal norms in terms of its content. Since they are the result of the coordination of the combination of both types of precepts, very briefly, they are the negative elements of the type. The theory of negative elements of type is based on this observation, which possibly constitutes the most important consequence of the incomplete nature of the precepts of the special part. It is said that a justified fact ceases to be at the same time typical. This is explained by assigning to the criminal type two parts, a positive one coinciding with the concept maintained by traditional doctrine. That starts from Balin. We are going to study this later, and another negative consisting of the absence of reasons for justification. What is the concept of blank criminal law? The precise extent of the concept of blank criminal law varies among authors. This way, Binding says that it is an authorization or delegation by a higher legislative body with respect to bodies of lower hierarchy. Metzger, for his part, expanded this concept by adding two assumptions: that the complement was contained in the same law. This is what he calls an improper blank criminal law, or that can also be found in another law, but emanating from the same legislative instance. This would be the second assumption of the blank criminal law, which it calls its own. The first would be the referral to lower level rules. Now let's look at some jurisprudence. Referrals in criminal matters are valid to the extent that the conduct has a common description and the penalties are determined by the legal reference. It would not be, says the Constitutional Court, it would not be obscene if penalties were made applicable or references were made by virtue of a law to behaviors established one or the other in a legal body different and separate from that one. However, this reference to other norms would only be valid in criminal matters if the conduct sanctioned had an exact and undoubted common description, and the penalties were precisely determined by the corresponding legal reference. so that it was not feasible that situations could lend themselves to disagreements nor confusion. Another extract of jurisprudence, also emanating from the Constitutional Court, says the abstract confrontation between the constitutional provision that establishes the principle of legality of the criminal norm. With the so-called blank criminal laws, it admits distinctions and nuances, a parameter under which those that contain an express reference from the law to the regulatory norms are tolerated, even when said complementary norm does not originate in the legislative process and whenever it is the norm of legal rank. The one that describes the core of punishable conduct, another extract in the current 8th paragraph 9 of the 3rd numeral of Article 19 of the Constitution. The existence of the so-called blank, inappropriate, or referral criminal laws has been tolerated. That is, those whose reference to describe the punishable conduct is found in another law, and those laws that expressly indicate the norm of destination of reference, even if it is not of legislative origin, with a description of the core pardon of the conduct that is sanctioned in this sense, are contrary to the Constitution. The so-called white criminal laws, own or open, that is, those in which the description of conduct is handed over to an infralegal norm without legally indicating the fundamental core of them, and those that hand over the determination of punishable conduct to the discretionary criterion of the judge. Finally, sorry. The Constitutional Court also says that the so-called blank criminal laws are those whose legal consequences are expressly established, but the content of the hypothesis is left to other laws, regulations, and in some cases to free interpretation.